Hello, my name is Sarah Lamar. I'm a partner with the law firm of Hunter McLean here in Savannah, Georgia, and I practice employment law. I've represented businesses, nonprofits, and government entities. And one of the most important laws that I deal with on a day-to-day basis is the Fair Labor Standards Act. It's one of the oldest employment laws in the country, passed in 1938. We all know the effects and the impacts of the Fair Labor Standards Act because it establishes the minimum wage and the overtime rules that almost all employers have to abide by. One of the fundamental elements of the FLSA, as it's called, is whether you are exempt or non-exempt. What does that mean? Non-exempt means you are entitled to overtime. You are not exempt from the overtime requirements. Exempt means you're not entitled to overtime for any hours worked over 40. All of us know that if you work over 40 hours, you get paid overtime, typically at time and a half your regular rate. If you're exempt, you don't get that, but employers have the burden of proving that someone is exempt from overtime. There are three well-known and so-called white-collar exemptions out there: the professional, executive, and administrative exemptions. For all of these exemptions, the employee has to be paid a minimum salary of at least $35,568 a year. On top of that, the employee has to do very specific duties that the employer must be able to prove. If the employer can't prove that the employee does those duties, then the employer may be on the hook for overtime going back 2 to 3 years. Often, it's not just overtime for that employee, but it could be overtime for all those employees in the same job or the same class. So it's a really good idea to periodically review all of your job classifications and ensure that your employees are properly classified as either exempt or non-exempt. This is best done with experienced HR professionals and your legal counsel.